Good morning and welcome to another edition of Tuesday Tips or Tuesday Talks with Julian Doby. And again, I practice law in North Carolina, have offices in Alamance County and in Southport. What I want to talk to you today about are medical malpractice actions because I get tons and tons of calls about people who believe that they have a medical negligence case. Not many attorneys handle these kinds of cases because they're very expensive and very hard to prove. There are a lot of statutory regulations and standards on attorneys and anyone who brings these types of cases. So you have to have a lot before you even file a lawsuit. Let's talk about what it takes to prove a medical malpractice case. First of all, you have to establish a duty. And that's usually established by the doctor-patient relationship. The medical care provider had to have treated you. That creates a duty to use reasonable care in the providing of those services. All right, next is a breach of that duty. And here's usually where it becomes more difficult. You have to show that the medical care provider somehow fell below the standard of care in that medical community in providing those medical services. This is where usually you have to hire an expert witness, and that expert has to be in the same field of practice and know the standards in that community of medical care. And that can become difficult finding other medical experts in that area to do that. The only way you wouldn't have to hire an expert is if there were negligence that just what they call res ipsa loquitur, which means it speaks for itself. In other words, you find a medical instrument inside the body after a surgery or a sponge. You wouldn't require an expert in a case like that. Next, you have to prove causation, and that's usually also done by an expert witness. Could be the same expert, but they have to testify or be willing to testify that that breach of duty of care actually caused damages to you, the patient. It can't just be assumed. And in doing that, that medical care expert is going to have to go back and review previous medical records at the time of the procedure, and post-procedure medical records. So it can be pretty costly to have all that reviewed by an expert, which makes these cases difficult to prove. And it's also why you need an attorney. And lastly, you have to prove damages that were caused by this breach of care. And that's also usually done through an expert witness. And loss of use, enjoyment of life, medical expenses, pain and suffering, all those things could be part of damages in a medical malpractice action. They're very difficult to prove, and you definitely need some legal advice as to whether or not you even have a cause of action. But if you think you do, give us a call, 336-221-8900 in Alamance, 910-380-0294 in Southport. Thank you. Have a good weekend.